There are some other grounds mentioned under these laws which are specifically available to the wife, which are: number 1, pre-act bigamy. In the case of a Hindu wife, she can ask for divorce if her husband has committed bigamy before the commencement of Hindu Marriage Act 1955. Number 2, rape, sodomy, bestiality. If the husband is guilty of any of these offences, then it becomes a ground for divorce for wife. Number 3, decree or order of maintenance. A decree or order passed against the husband awarding maintenance in favour of wife becomes a ground of divorce under Section 13, subsection 2, clause 3 of the Hindu Marriage Act 1955. Number 4, forcing into prostitution. Under the Parsi Marriage and Divorce Act 1936, this ground has been recognized as fault ground for which the wife can approach the court for divorce. Number 5, neglect and non-maintenance. If the husband has neglected or failed to provide for maintenance for a period of 2 years of a Muslim wife, she is entitled to divorce under Section 2, subsection 2 of the Dissolution of Muslim Marriage Act 1939. Number 6, other grounds under Muslim law. A Muslim wife can also seek divorce under various grounds such as khula, zihar, laim, etc. The fault theory implies the existence of two things. Firstly, fault of one party for committing any of the specified matrimonial offences, and secondly, innocence of the other party who has been outraged and has no role in commission of such offence. Therefore, it is necessary that relief-seeking party should come before the law with clean hands, which is why it is sometimes also referred to a clean hand theory. There are certain defences available against the theory which are particularly known as matrimonial bars, and these are: number 1, recrimination. It is presumed that the complainant must come before law with clean hands. He or she should not have in any way committed any matrimonial fault in comparison to the fault of his or her spouse. Therefore, a wife cannot claim divorce on the ground of non-consummation of marriage if she has herself deserted the husband. Number 2, accessory. The petitioner must not have been accessory to the fault of the respondent. Number 3, condonation. The petitioner should not have forgiven the fault of the spouse either in implied or express form. Number 4, connivance. Non-opposition to the spouse's marital misconduct, like in the case of adultery, will weaken the case of petitioner. Number 5, collusion. There should not be any hidden agreement between spouses to seek divorce unless it is in consonance with the consent theory of divorce. Number 6, reconciliation. Resumption of marital obligation works as a matrimonial bar at the time of granting of divorce. Number 7, delay. There should not be any unnecessary or improper delay in instituting proceeding for divorce after the finding of fault of the spouse.